control because they were not investigating.
And you said, for lack of a better phrase, when you said well-oiled machine, you're talking about the entity of a public office with people hired, people vetted, have to go through background checks to determine whether or not they are worthy of the badge that comes with being a prosecutor in those offices, with supervision and a process to follow. And you're telling us that there was an individual that never passed those checks, never had that responsibility, never felt the weight of that ethics, and his referral to the Attorney General for that job was Nate Paul?
Yes, and further, they were signed Special Prosecutor of the Office of the Attorney General, which is a title that does not exist, and under the authority of Ken Paxton himself as Attorney General.
So is it fair to say the OAG's office was effectively hijacked for an investigation by Nate Paul through the Attorney General, Ken Paxton?
That would be my opinion.
And Vice Chair Johnson, I apologize.
Mr. Spiller has a question.
Just to clarify, as again, my colleague, Ms. Hepley, has noted, following up on your question, as I understood, was General Paxton warned many times that the pursuit of this action could lead to dangerous consequences? And the answer that I intended to provide was yes, that is in fact the case.
And despite those warnings, he went forward with it anyway?
That is correct. Sir.
Mr.
Yeah.
Spiller.
Thank you, Mr. Chairman. So in short, you're telling this committee that Attorney General Paxton insufficiently and in an unauthorized way allowed someone to act on behalf of the Office of the Attorney General and the state of Texas, and that person issued subpoenas on behalf of, grand jury subpoenas in a legal process on behalf of the Attorney General and the state of Texas in this criminal investigation.
That individual represented himself, as mentioned, as a special prosecutor for the Office of the Attorney General, acting under the authority of the Office of the Attorney General to seek and obtain grand jury subpoenas.
With no written authorization that we know of at that time.
To be clear, no properly approved, no, I don't want to use the word properly. Let me change that. No approval based on standard operating procedure.
Okay, thank you.
So you want to tell us a little bit more about what approval there might have been?
The approval was directly from General Paxton himself. It's our understanding through our investigation that the approved contract was authorized by the Attorney General, was not authorized by any individuals along that chain, which is, of course, the normal procedure, and again, stands out as unique in this situation. The motions to quash that were presented on all 39 subpoenas were reviewed by an independent judge who took action immediately and quashed all subpoenas. The senior staff took it upon themselves to then provide that information, the quash subpoena ruling, to those who were affected by the grand jury subpoenas that were sought. And again, there were two general targets of the grand jury subpoenas. One were the financial institutions and individuals related to Nate Paul's civil litigation and civil litigation concerning Nate Paul-controlled entities. And number two, law enforcement related to the federal investigation, including magistrate judge and other law enforcement personnel. The first part, the financial institutions, some of those banks were associated with the Mitty litigation, the Mitty Foundation lawsuit and litigation. The second part, the law enforcement related information, would have been information that could have been part of the open records request that was initially sought and covered by Ms. Boos.
So I want to summarize really succinctly, and I'm not trying to put words in your mouth, but what your investigation of allegations by whistleblowers tells us is that the Attorney General himself chose to hire an attorney with 5 years' experience based on the recommendation of Nate Paul's attorney give that attorney some job title that doesn't even exist with the Office of the Attorney General, and somehow give him the authority to issue 39 subpoenas to go after business interests for an individual and law enforcement that is conducting an investigation on that individual.
That's correct.
And part of that goes right back to the charitable organizations, which state policy says the Office of the Attorney General is there to protect and shelter and look after them because they're doing generally good for the state of Texas.
There was a connection between those banks and the Mitty Foundation lawsuits.
Wow. Vice Chair Johnson has questions.
In addition to financial records with regard to the civil litigation, you said law enforcement magistrate judge, and it was not clear to me. Are you suggesting that the requested information from Nate Paul about the unredacted FBI file as to the entities and the people that were investigating him and executing that search warrant? So normally we may redact information as described to protect witnesses, to protect agents who are involved in an investigation. Are you saying that the grand jury subpoenas were attempting to obtain information that only could have been known if you had seen the unredacted FBI file?
What I will say is this, Vice Chairman Johnson, having done this for a number of years, and my colleagues as well, it would be extremely difficult to find out the information concerning the magistrate who signed off on a search warrant, specific individuals involved in the process leading up to the authorization of a search warrant, without having some sort of knowledge about the inside information of that agency.
And I just want to circle back to something that was said almost a couple of hours ago. That unredacted file was put in an envelope and given to Ken Paxton that was kept in his personal possession for a few days.
I will let Ms. Booth cover that, but I don't think we can say that that is in fact the case, that that document was in the manila envelope. What we can say is that the unredacted memo was in the possession of General Paxton for a period of time.
So two different things. One, the unredacted memo gives directly to General Ken Paxton.
Correct.
At some point, Ken Paxton gives a manila envelope to an aide that then drives that manila envelope to Nate Paul's business in Austin and hands it over to them.
That is correct, to him personally.
To him personally. And then at some other point, grand jury subpoenas 39 are issued asking for information related to the people that would have potentially been in that report.
That is correct.
That's correct.
What kind of information were they wanting on the magistrate or the police officers that were involved in investigating Nate Paul?
I don't have the specifics of that, but it's our understanding, and it's been explained to us, that it included information, including personal cell phone information, cell phone records, IP addresses. But I don't have the entirety of the scope.
Chairman Longoria?
Thank you, Chairman. Did you have the opportunity to review that DocuSign or that document with Special Prosecutor Kamek and the AG's office, like on the terms? Was it hourly? Was it salary? What was this?
You have the... Aaron,
May I
please.
respond? There is a draft contract that would have included
Use the microphone.
Yep, thank you. Sorry, Chairman. There was a draft contract that would have included additional information, for example, the hourly rate or the scope and terms of employment. That, as drafted by Ryan Vassar, limited what Brandon Kamek, even if hired, would have been able to do to purely investigative. He cannot be the prosecutor. That's first. Second, you'd asked if we were able to review the DocuSign documents. We do not and cannot provide or get access to that until or unless the Attorney General's office willingly provides it, or until this legislature forces them to provide it subsequent to a subpoena. But what I can tell you is that portions of the document for the DocuSign are included in the OAG report response. It can provide, for example, when the document was created, when it was last touched. If you would allow me some latitude, I'd like to come back to Vice Chair Johnson's question. Some of your questions have involved whether or not there was a valid contract. Two things. Can the Attorney General hire a lawyer himself on the back of a napkin if he wants to? That is not part of my job description to decide, but I would presume there can be a colorable argument. The answer is yes. So there's two questions. One, they did not follow the internal policies and procedures designed to protect Ken Paxton, to authorize payment of an employee, and to document what proceeds. But second, the draft they do receive is signed and not dated, which is very important because just because it was provided upon request with both signatures does not establish when that occurred. And what we know is that Brandon Kamek was working for at least 2 weeks before Ken Paxton told Penley, you need to sign this document suggesting no contract exists because Brandon Kamek is already working. So I want to say when we refer to contract, we're not establishing its validity. We're referencing what we know from Attorney General Ken Paxton.
Vice Chair Johnson.
And if I may, what bothers me is not the idea of whether or not he can hire or not hire. What bothers me is the fact that not everybody gets to be a prosecutor. Not everybody is qualified to be a prosecutor. Not everybody can pass the credentials, the criminal history, or the vetting determine whether or not that person is an ethical lawyer that's entitled to the power that comes with being a prosecutor. And what it sounds like you're telling us is that all those people that were on that front line of defense of ethics in the OAG's office were telling Ken Paxton, you may not do these things and you may not hire this person because they don't reach our standard. And he did it anyway.
That's correct.
Was Kamek, you mentioned 25,000 was allocated for this spot. Was he paid? Do you know?
He did submit invoices. Don't have the information on whether or not he was ultimately paid on it, but he did submit invoices even after the motions to quash had been filed.
Okay. Multiple invoices? Because you say invoices. So
Yes.
Okay.
Mr. Donnelly, do we know if Mr. Kamek challenged the subsequent actions of high-ranking OAG folks to quash the subpoenas?
We have no information that occurred.
They haven't provided any information that he, showed up one day or made a phone call and said he's upset about what they've done.
That's accurate.
Okay.
So again, Mr. Kamek submitted those invoices. General Paxton took no action to halt or postpone the actions taken by Brandon Kamek. General Paxton, as Vice Chair Johnson indicated, inserted himself into this matter directly, hired outside counsel in a manner outside established and codified procedure. The actions were grossly outside of the line of established norms. And as we've been able to determine, based on our investigation, the only beneficiary of the fruits of the investigation, notwithstanding its lack of legal or credible basis, would have been Nate Paul.
Any questions on those topics for Mr. Donnelly?
I don't think we have any questions right now. They're just some very serious facts.
Thank you. In that case, I'm going to turn our attention to the retaliation component. I've structured it in a timeline, so it should move quickly, but please step in if you have questions. The facts, as you have just heard, in regards to MIDI, open records, the letter foreclosure, and the investigation, all functioned in individual silos. They had line prosecutors, then mid-management, and ultimately senior-level Office of the Attorney General employees involved, increasing as the level of concern or pressure progressed. But very few senior leaders in OAG had the landscape of what was occurring. They were not involved in each silo. They did not have the full scope. That comes to a head on September 28th of 2020, the first Monday that a grand jury subpoena is received. When that happens, questions begin to be asked as to why someone named Brandon Kamek is alleging that he's a special prosecutor with the Office of the Attorney General. I would advise this panel that senior staff at the time who would have been responsible for overseeing a special prosecutor in the Criminal Investigation Division had no idea who Brandon Kamek was. When looked in the internal database, there was no reference to an individual named Brandon Kamek. When his LinkedIn or Google profile were reviewed, there was nothing familiar about his face. So the senior level advisor decides to start contacting other leadership to find out what's afoot, why they weren't looped in, and why, despite a very deep, experienced, well-funded roster of criminal prosecutors and investigators in the Office of the Attorney General, they would ever need outside counsel. Couldn't recall a time that had been necessary before. This is the first 2 days of that week. By the time the second grand jury subpoena is notified, leadership falls into what I think they would tell you is not just grave concern, but chaos. They're concerned that Brandon Kamek has gone rogue. They do not know under what authority he has acted. Attorney General Ken Paxton is not present in the office, so per law, the first assistant is the acting Attorney General. They decide to reach out to Attorney General Paxton and let him know what is going on. The response is that he, Ken Paxton, had hired Brandon Kamek, to the surprise of every other employee at the Office of the Attorney General. No internal documentation, no checks and balances against other individuals, no requests as to the limitations of power, no reference to the fact that he had actually been hired. At that point, Penley sends a cease and desist letter to Brandon Kamek. He states that he has no authority and that his actions may be illegal. The staff emails General Paxton to notify him of Kamek's actions. Paxton responds that he had hired Kamek without telling them. Again, no documentation and no DocuSign. I would point out next that Kamek sends an invoice for his services as relayed by Mr. Donnelly a moment ago. The staff asks for a copy of that contract. Brandon Kamek cannot provide it at that time. This is Wednesday, September 30th of 2020. When that contract arrives, it is signed but not dated, despite evidence internal to the organization that there were still questions on behalf of the Attorney General as to whether or not he had the authority to sign outside counsel, a question that would be irrelevant if an actionable contract was already in place. Staff at the Office of the Attorney General contacts Don Klimmer at the Travis County District Attorney's Office. Klimmer says they did not hire Kamek.
Vice Chair Johnson has a question.
Yes.
So how long is his supposed employment between the time that Ken Paxton says, I'm hiring him, gets somebody to sign off, he issues grand jury subpoenas, and then he gets blown in September 28th to September 30th?
The only possible people who could answer that question would be the Attorney General Ken Paxton and Brandon Kamek. What I can tell you is that he used information he could not have had until September 23rd in making the request to the grand jury subpoena. That is the only anchor of a time frame we can give you until that Monday, the 28th.
So we're talking about a couple of weeks?
According to the general himself, Brandon Kamek had been working for several weeks and needed to be paid, and that conversation was had on September 28th.
And for several weeks, the Attorney General authorized $25,000 in taxpayer funds to go to some kid that's never been a prosecutor to do a couple weeks worth of work?
Yes, I do not want to state that there was an agreement for the full $25,000. There was an allotment. I don't know how that agreement would be structured. There's evidence that it was $300 an hour, but that was the official draft contract if hired per standard procedures in the Attorney General's office. We have no way of knowing what agreements, if any, existed between the parties otherwise. At that point, Wednesday, September 30th, yes, no questions. At that point, Wednesday, September 30th of 2020, the leadership in that office goes to the FBI. I want to emphasize where we started at the beginning. 4 individual silos functioning independently, each with concerns. Each staff or leadership has pushed back on General Ken Paxton, advised why this is ill-advised. We have at least 3 specific conversations in which parties who otherwise have not compared notes warned General Paxton about the appearance of bribery, the implication of compromise on the office, and advise him to cease his actions. And that doesn't happen. At that point, the senior staff goes to the FBI and makes an account as to what has occurred. This brings us to October 1st of 2020, a Thursday. The 7 employees text General Paxton to notify him that they have reported his violations to the appropriate law enforcement authority. To hearken back to what brings us here today, those people acted as the evidence and their testimony would provide in a way they believed to be loyal to General Paxton for as long as they could, and then were obligated to make a report, the same type of report that would be protected by a whistleblower lawsuit or a whistleblower action. The whistleblowers provided in that notice letter to the Office of the Attorney General, Human Resources, quote, "We have a good faith belief that the Attorney General is violating federal and/or state law including prohibitions related to improper influence, abuse of office, bribery, and other potential criminal offenses. It is for other bodies to determine whether or not those allegations are valid. But what it, without question, exists is if those individuals acted on good faith when they made the violation, they are to be protected. And as we will walk through in a moment, each one of them was fired or resigned on their own principles or suspended and then terminated at the conclusion. October 1st, 2020, CAMIC returns the draft contract for outside counsel signed by General Paxton and without a date as to when it was executed. I think we covered this earlier, so I'm going to keep moving on unless there are questions. Darren McCarty directs the Charitable Trust Division to non-suit or withdraw from the Mitty case. What this means is that the Office of the Attorney General has intervened, which is a neutral action. Their actions, according to testimony, is contrary to Mitty, and at the time they do the non-suit, they have withdrawn their involvement in the lawsuit. So they've removed themselves as a party. I would like to clarify something earlier. Ms. Boos had recounted to you that there was an agreement and a settlement in regards to the properties for $21 million. That is accurate. We're criminal lawyers, however, and not civil. So what I will let you, or what I would advise is the time for appeal on those properties has not concluded, so it is not final for other purposes, but that is the agreement and the expectation. Still October 1st, 2020, Penley writes Clemmer, that is Office of the Attorney General, reaches out to Travis County DA's office to tell him that CAMIC has no authority, so the grand jury subpoenas are improper. There have been allegations and debate as to whether or not there's some sort of violation for providing those grand jury subpoenas. There was no jurisdiction on the part of the Office of the Attorney General to issue those grand jury subpoenas. They did not have validity on their face. If, to backdate validity, the Travis County District Attorney's Office agreed they had control and management, then there is a colorable argument that has been corrected. That does not and never did exist. The Travis County District Attorney's Office did not confer that privilege on Brandon CAMIC. They didn't know he was working on these matters. At that point, Clemmer collects the grand jury subpoenas and directs the Office of the Attorney General to file a motion to quash, legal speak to say pull back or withdraw to end the ability to use those subpoenas. October 2nd, 2020 is a Friday. Travis County District Attorney's Court Judge signs the motion to quash, ending the 39 subpoenas. Jeff Mateer, First Assistant, resigns on principle, given the actions of the Attorney General's office and General Paxton himself. Penley and Maxwell are placed on administrative leave as a direct result of the events from the preceding week and the report that they have made to law enforcement in regards to the actions of Attorney General Ken Paxton. Near this time, another senior employee decides that they have put their job at risk by acting as they believed to be appropriate. They send an email to the Human Resources Division notifying them of their involvement in the motion to quash and expressing concerns about adverse personnel actions. That person stays on staff for at least another year, doesn't move forward, loses scope of power, loses authority, and ultimately is about to be demoted, and believes the only reason they were allowed to stay for that year was because they had documented their concerns as to adverse personnel actions. October 5th of 2020, Monday, Brent Webster dismissed Brickman from an important legislative meeting with General Paxton.
Would you clarify who Brent Webster is? That's the first time I've heard that name.
Yes, I will. Brent Webster comes in on the first assistant leaves, and by that Monday, Brent Webster has been recruited to be the new first assistant of the Office of the Attorney General. There is evidence based on interviews and phrasing in the document referred to as the OAG report that he was the person who conducted that investigation, attempted to clear the Attorney General's office, and wrote the report. It is an unsigned document, the OAG, so I cannot establish for you who ultimately decides they want to take credit for that, other than the Attorney General has posted it on his website.
Do you believe that Mr. Webster is an internal promotion, or did he come from outside the agency?
He came from outside the agency. We have very limited information in regards to the fact that he might have previously been affiliated with a lawsuit on behalf of Nate Paul. I have no personal knowledge of that,
Okay.
but would be remiss not to add it.
Thank you. I know I interrupted you, but Speaker Guerin, did you have, okay. All right, please continue.
Within a few days, Ryan Vassar is placed on investigative leave. October 9th of 2020. The Travis County District Attorney's elected District Attorney Margaret Moore sends a letter to Attorney General Ken Paxton. I would like to read it here despite its length if you would allow me. Dear Attorney General Paxton, on June 10th, 2020, my office sent to David Maxwell, that is the investigator internal to OG, a letter referring a request to investigate RTI filed in our office by Nate Paul. The RTI was received by us after you asked my office to hear his complaints. The referral of the Office of the Attorney General was made with your approval. We did not conduct any investigation into the merits of the matters complained of. In referring the matter to OAG, we concluded that ours was not the appropriate office to either address the matters raised in the complaint or to conduct an investigation into them. The referral cannot and should not be used as any indication of a need for investigation. A desire on the Travis County DA's part for an investigation to take place, or an endorsement of your acceptance of the or an endorsement of your acceptance of the referral. My office has closed this file and will take no further action. Furthermore, I have instructed my employees to have no further contact with you or your office regarding this matter. Any action you have already taken or will take pursuing this investigation is done solely on your own authority as provided by Texas law. The newly surfaced information raises serious concerns about the integrity of your investigation and the propriety of your conducting it. That is from the District Attorney in Travis County to Attorney General Ken Paxton himself. October 15th of 2020, Brent Webster extends the administrative leave for another 2 weeks in regards to David Maxwell and Mark Penley. October 20th, 2020, Blake Brickman and Lacey Mays are terminated. They are fired from their employment at the Office of the Attorney General. October 28th, Ryan Bangert resigns. November 2nd, 2020, David Maxwell and Mark Penley are terminated. They're fired from their positions at the Office of the Attorney General. And by November 10th or thereabout of 2020, Ryan Vassar is terminated. I would point out, as it's relevant here, that throughout the interviews that we had done, it was clear that outside counsel in the Criminal Investigations Unit was unnecessary at that time frame. There is then a loss of personnel in terms of body count. There's also a loss of personnel in terms of experience and depth. And at this stage, the Office of the Attorney General spends approximately $40 million a year on outside counsel in an office that previously was well-funded and had a deep roster. At this point, I would turn your attention to Greg Cox. You will remember him because he was related to the securities fraud investigation in Travis County. Moving forward to 2020, Margaret Moore is still the elected district attorney. The whistleblower actions have blown up, and Greg Cox is asked to return to the Travis County District Attorney's Office, given his experience in special prosecutions, and to look into the allegations of bribery. He makes headway, begins to substantiate allegations and claims, and ultimately is asked to step back or to stop because there would be a pending federal investigation. As I think people would expect, we defer and respect to federal authorities, but it also means that progress for other purposes ceases because of their investigation being ongoing.
Can I interrupt you?
Yes.
Would you clarify a little bit, if you can, who asked him to stop? Is that DA Moore that asked him to stop, or is that the Department of Justice stepping in saying, hey, we're working on something, please stop, halt your investigation?
Thank you for that question, Chairman. No, the district attorney herself had asked him to look into, not to prove or disprove, but to follow the evidence as to whether or not there was sufficient evidence to proceed on bribery concerns and investigations and to other offenses. It was the federal authorities and law enforcement, either prosecutorial or investigative, who asked him to step back.
Thank you.
Yes. Before we conclude,
Just to clarify, when did federal authorities say, hey, hold off on your bribery charges?
that is absolutely included in our records, but I did not include it on this, and I don't want to speculate as to
But that wasn't just within a few days of their work?
No.
That was after
No.
weeks or months of work had occurred?
That's correct.
Okay.
Before we conclude, I had mentioned that I would like to highlight some information from the Office of the Attorney General report. Now, the references that come from me are attributed directly to evidence we have received in either documentation or in conversations with people relevant to the specific events. So the opinion that they're false or misleading is based on contrary evidence.
And
But
we're
for-
talking about the 400-page document that was submitted online as a response to all of this.
Yes, Chairman
By,
Moore.
by the Office of Attorney General.
That's correct.
Thank you.
When I reference as false or misleading, it's not my personal opinion. It is what appears to be the case based on testimony and evidence, but for brevity, I will refer to it that way. I am also not going to give you an exhaustive list. There is frankly not time, and some of them are repetitive. But some highlights. First, there's a quote, "As this investigation remains ongoing, this report will be updated and supplemented as further interviews are conducted and if any additional evidence is obtained." There have been no supplements and no amendments or additions. I have organized these by theme to aid, so I'm going to give you a prompt first. In regards to the first allegation, for this list, that will be the open records request. False statement. Paxton's actions were lawfully taken, page 46. False. In regards to the second claim, for this list, that will be the Mitty Foundation. Quote, "Ken Paxton's involvement was consistent with his predecessor and in line with his required duties and legal obligations as Attorney General." Page 5. False. Quote, "Position taken by the Attorney General in this litigation was adverse to Nate Paul and in support of a higher settlement to be paid by Nate Paul." This is referencing a letter from an attorney for Nate Paul. That's on page 5. False. This investigation revealed that the Office of the Attorney General's intervention worked to the Foundation's advantage in mediation. Page 49. False. In regards to the third allegation, for this list, it will be the foreclosure letter, or what some internally call the midnight letter. Informal guidance letter regarding foreclosure sales written by Bangert was made in response to a request for disaster counsel advice from Texas Senator Brian Hughes. Page 5. Misleading. It did come from Senator Brian Hughes after drafted and provided by the Office of the Attorney General. No crime is alleged and no evidence of any crime is articulated. Page 49. False. It cannot reasonably be argued that this was an unusual or unwarranted result, meaning the position taken by the Office of the Attorney General on the foreclosure letter. Page 50. False. The fourth claim in regards to special prosecutor and the investigation by Brandon Kamek. In regards to Kamek, knowingly appointed as special prosecutor by Travis County District Attorney's Office. Page 6. False. Brandon Kamek legally and properly exercised authority delegated to him by the Attorney General Paxton, pages 5 and 6. False. Referral number 2 was never investigated by any OG staff, page 42. False. This statement is not only false based on the evidence acquired by this inquiry, but is directly controverted by another quote in the same document. No one at OAG was then aware of the existence of referral number 2, which was true, with the exception of Paxton and Kamek, also true. Only Kamek had access to the contents of referral number 2. Paxton read referral number 2 after OAG's internal investigation had begun. In regards to the Travis County District Attorney's Office control or management of the investigation, Clemmer and Montford independently approved the criminal complaint and referred it to OAG for assistance in the investigation for the reasons discussed in the report, page 52. False. Claims against the potential defendants in referral number 1 and referral number 2 were never ruled out, page 7. Misleading. You cannot prove a negative. They were determined on the face by the Travis County District Attorney's Office present at the lunch and by the investigators and assistant attorney generals in the first meeting at that office to be meritless and not worth proceeding on their face. Quote, Travis County District Attorney's Office did initially investigate and referred the matter to OG, page 39. False. Travis County District Attorney's Office requested OG's assistance with this investigation, page 39. False. Quote, therefore, under Texas law, Travis County retained legal care, custody, and control of the OG investigation. False. Montford and Clemmer, ellipses to remove the center, oversaw the special prosecutor, page 39. False. Referral number 1 and referral number 2 undeniably indicated a need to investigate, page 39. False. They expressed Travis County's desire that an investigation take place. False. They constituted Travis County's endorsement of the referral. False. In regards to the subpoenas, Travis County District Attorney's Office assistance with subpoena confers special prosecutor status. False. As a side note, Article 20.03 regarding the use of the grand jury, as indicated earlier by Mr. Donnelly, is quoted as reading, the Attorney General, District Attorney, Criminal District Attorney, or County Attorney may be the attorney representing the state, page 8, which makes it intellectually dishonest to say that the Travis County District Attorney's Office subpoena conferred special prosecution status from their office. Continuing the quotes, Travis County District Attorney's Office presented Kamek as a special prosecutor, implying with the Travis County District Attorney's Office, upon providing grand jury subpoena requests to the judge. That's false. Kamek had authority pursuant to Travis County District Attorney Office appointment, page 34. False. Do you want me to keep going?
Please.
Thank you. Quote, the Travis County District Attorney's Office, ellipses, because there's commentary in between, held control over all decisions regarding the subpoenas presented to the court. That is false. An attorney for Nate Paul was present, and that may have been required to waive any objection to releasing the information if Paul, his client, was a party or owner of the subpoenaed bank records, page 52. False. Also in Texas code is the requirement that parties not be present for the service of a subpoena. I add that because the attorney's presence with the outside counsel, Brandon Kamek, in service of criminal subpoenas related to civil process is concerning. Quote, beyond that, the complainants articulate no theory of a criminal act, much less a theory that Attorney General Paxton sought or accepted a bribe or otherwise improperly exercised his official influence, page 56. That is false.
Vice Chair Johnson has questions.
Have all of you been involved in the interviews with the people from the OAG's office or the whistleblower at some level?
Yes.
Yes.
Okay. Do you get a sense of, from them, their feelings about what the actions of the Attorney General have done on the institution of the Attorney General's office?
Yes.
Can you share it?
Of course. Does anybody else want to field it? Been talking for a minute.
Fair enough. The thing that I think struck all of us in our investigation, not only in speaking with whistleblowers, but other high-ranking officials at the Office of the Attorney General, is that these are individuals who are extremely well-credentialed and qualified. These are individuals who have taken upon their role as public servants to do what their oath is, what their oath asks them to do, to uphold the laws of the state of Texas, to uphold the Constitution. Many of the people that we spoke with, specifically some of the whistleblowers, are known outside of the Office of Attorney General circle. They are well-respected former law enforcement. They are well-respected attorneys. They're individuals who are considered subject matter experts in fields. They are oftentimes the cream of the crop. They rose to the positions that they are in because of their work ethic and because of their dedication. And the feeling was shared almost universally that the actions that they were being asked to take, the positions that they were being put in, the decisions made by the Attorney General sullied the office and sullied their commitment and their careers.
Chairman Longoria
Thank you,
first.
Chairman. You mentioned early on something about water damage at a home. Can you elaborate on that?
I certainly can. In the summer of 2020, a home belonging to General Kenneth Paxton and to Senator Angela Paxton was being renovated. As we understand it, those renovations began because that there was water damage in the house. And like anyone, you want to fix cosmetic and damaging issues in the home, but evolve into a full-scale renovation. The quote to us was involving everything from tearing out the floors all the way up to the ceiling. We have evidence that there were upgrades requested to both the countertops and the cabinets. I don't mean that as a limitation to other things. I mean it is to the two items I can specify information specifically related to. And in regards to the counters, General Paxton was observed and overheard having a conversation with the person who was functioning as the contractor on site. During that conversation, General Paxton relays that he wants an upgrade to the granite countertops, specifically that his wife doesn't like them and she would like different countertops. The contractor relays that that will cost an additional $20,000, and the response from General Paxton is that they should proceed. He wants to do it. And then the information available to this inquiry and intimated in the allegations by the whistleblowers themselves was an implication of impropriety. Specifically in regards to the $20,000 upgrade, the contractor's response was, I'll have to check with Nate.
Nate being Nate Paul?
My job here is to provide you the information that I can. The evidence supports Nate. I don't know of another Nate that is relevant to any portion of the inquiry in any way. I know that Nate Paul has ties to commercial real estate and real estate in the Austin area, and that he was relevant in other silos of information in regards to the same time frame.
And where was this property located?
I don't want to give the address.
Well, not the address, but what county or?
Austin in Travis County.
Was there any permits
No.
obtained?
Thank you for asking that question. Attempts were made by this inquiry to find out greater detail in regards to the contractor themselves. We have a first and last name of an individual who's been subpoenaed. We have information in regards to a business owned by Nate Paul that was alleged to have been included, and subpoenas have gone there. We have looked into the permitting, and no permits were pulled for the property in the year of 2020.
You mentioned water damage, and I hate to assume, but was there an insurance claim filed, or was this private pay? I mean, how was this?
I do not have information in regards to that. Do you want to get into Bola? The China budget. Do you want to get into the Chinese budget? Okay. Yeah. Thank you. I wanted to clarify something else to ensure not to go on a tangent. But no, that's all we have on that.
Okay. All right,
Thank you.
You did mention that it was a home in the course of your inquiry and investigation. Is that the only home for the Paxtons?
No, and I invite the team to contribute here as well. I know that there are at least 2 houses in the Travis County area that are attributed to the Paxton family, a condo and the home under renovation. That there is a house in College Station, Texas. There's information in regards to at least 2 other properties. Yeah. One in Collin County. And we're in the middle of getting additional information in regards to those pieces.
So there's a lot of different homes.
That's correct. And potentially 2 currently under Texas homestead exemption, when the expectation is that there be 1.
That's duly noted. Members, do you have any questions about what we've covered so far? I know we have some other topics. Speaker Guerin?
Yes, ma'am. Ms. Epley, could the report that you were discussing, true and false and true, who generated the report that you were quoting from?
The best answer I can provide you for that is policy allows that no one beneath the first assistant of the Office of the Attorney General has permission to publish on their website. So the best I can tell you is Brent Webster or General Paxton authorized the publication. The second thing I will tell you is that because it was posted on the Office of the Attorney General website under the authority of Ken Paxton, there's an admission of adoption argument in regards to the veracity of that information from his perspective. It was not signed.
But the report was generated by the Office of the Attorney General somewhere in the office, and put on the OAG's website. Is that correct?
Yes, sir.
Thank you, ma'am.
Now, just to summarize, you have downloaded to us and to the public a great deal of information that we as a committee had requested regarding the whistleblower allegations. From your professional point of view, and I'm not trying to put words in your mouth, but you've spent hours visiting with various individuals. Their attorneys were present. Everything was handled very professionally. The allegations that are contained, that were made as part of the litigation for the whistleblower lawsuits, do you feel like there's a lot of evidence there to support those allegations?
I do. Yes, Chairman, I do.
I do as well. Yes.
I do.
Okay. And as part of that, I know part of our inquiry then would go from your professional point of view when we talk about what violations may have occurred. Can you enlighten us in the course of your investigation as to what those might be?
Yes, Chairman, I may, but if you would indulge me, I'd like to respond in two pieces.
Please.
First, the scope of our inquiry was related to malfeasance, which is, unlawful criminal activity, misfeasance, so lawful activity taken in an illegal way. And we have responses in regards to both. But given Donna Cameron's extensive experience as a division chief in public integrity and her work specific to this area on behalf of the inquiry, I would like to pass the mic to her.
After you've heard all the allegations of misconduct and malfeasance, I would like to briefly summarize violations of the law that we feel like the evidence shows that it would meet the elements of the crimes.
And I'm going to get you to pull your microphone closer for those that are listening.
Okay. And we're also talking about violations of the oath. So the first would be gift to a public servant. And that is a misdemeanor, and that could relate to the home remodeling. It could potentially relate to the campaign donations. Another thing that I want to talk about, which is a lot more serious, the abuse of official capacity. And this is when you have somebody in the someone in the office of the Attorney General who, in his position, comes into the custody of all this personnel, all the, property that the OAG has access to. And what the allegation is that there is over $72,000, and that is very conservative of the time and efforts that these really high-ranking, respected employees were not just diverted to, but basically demanded by the Office of the Attorney General to divert their time to. And that would be a third-degree felony. You've heard about the securities fraud. That's from 2011. That's a felony in the first degree and a felony in the third degree. We also have securities fraud that has been mentioned from 2004, 2005, 2012. The other issue is a third-degree felony of misuse of official information. So if non-public information comes to you by virtue of your position, such as, the unredacted documents that came from the FBI when the OAG...
That's a really good example, such as files from the FBI.
Right, right. When you are getting highly sensitive information in your position and you then release that to not just the public, but you can release it to one person. And the circumstantial evidence shows that that information was obtained and was perhaps given to Nate Paul. let's talk about retaliation and official oppression. And what we have here is the kind of actions that were taken by the Office of Attorney General towards his most senior employees and subjecting them to all kinds of retaliation that you've heard. And that is a third degree and a misdemeanor. Now, I want to talk about, excuse me, misapplication of fiduciary property. Because the easiest way for me to think about this is here is the Office of the Attorney General, and he's in the position of a fiduciary. So he has the entire budget that gets provided to him and his office, and he makes decisions on how to expend those monies. And I wanted to look particularly at the hiring of Brandon Kamek. That contract was entered into for a year. And that money that was set aside, $25,000, we don't know how much has been paid out. We don't know what the invoices were. But it was subjected to substantial risk of loss. We don't know that it's gone. The $72,000 regarding the employees who were, diverted, that's gone. That's gone, and that's conservative. But this $25,000 was specifically earmarked. And, the things that when you say intentionally, knowingly, or recklessly misapply, the kind of reckless, things that I believe that the Office of the Attorney General did was basically, as the other people have told you, he was a 5-year lawyer, no prosecutor experience. And this contract was entered in to give him $300 an hour. So, that to me is at the very least reckless. He was also encumbering $25,000 of the state's money. He was also told that, all people in the office that were required to sign and approve this DocuSign had not done it. He was also told by his high personnel that this could be criminal activity, that this was only for the benefit of Nate Paul, and not just for the benefit of Nate Paul, but for the harm of entities. So we're not just talking about benefit, but we're talking about harm.
May I ask about, you mentioned retaliation, and I wanted to ask for those of you that talk about the whistleblowers, is there a direct connection when they talk about, or y'all have described in them, a fear or a concern of retaliation? Is that emotional? Is that mental? Is that physical? Is that employment? What kind of retribution did they describe?
I think it's a combination because they felt like they were harassed, that there were false statements put out, that it affected their reputation, that it affected their ability to get another job. These were people that had high-level, respectable jobs, and then they went down for less money. Some were out of a job with, 6 kids, whatever. But it was just...
There was realized harm to the whistleblowers.
Yes.
May I interrupt just briefly? Sorry to interrupt.
Yeah.
We didn't spend a great deal of time on this area because it's their personal lives. But to your question, the retaliation isn't just the suspensions. It's not just the firing, although that is the most salient in regards to the whistleblowers and the most significant for today. But there are also people on staff who, for example, found out about the affair and confronted Attorney General Ken Paxton, who ended up with a pay raise, but moved out of their scope of employment with less access, with less control. So,
Wait. So there were people within the office that when they found out about the affair, I don't know that can you explain that
Yes.
to me again? I'm not sure I caught it.
yes. So there were people in the office who, once they found out about an affair, not that they'd sought it out, they received information or acquired information in regards to an affair. The allegation is that they have conversations with Attorney General Paxton about that, about the appearance of that, about implications in terms of opening the office or himself, up to concerns of blackmail or bribery or impeachment, right? And so as a result of that conversation, that person is not terminated or suspended. That person is promoted and given a pay raise. But they're moved in terms of their access, and they're moved in terms of their scope of employment to have less access to Attorney General Ken Paxton, to the staff at large, and to policies and procedures in the office.
So somebody discloses to him, hey, you're busted on the affair. This looks bad for the office. And his response is to move them, give them more money, and give them less responsibility.
Yes.
Did they want that, or was that okay with them?
I don't know how to answer that question. I know that in regards to what harm came to you in regards to conversations or confrontations with General Paxton, this was an answer that was provided. So to them, it was negative. Who's going to decline money for a job that you love in an environment you care about before you realize that you're being moved out and punished?
So when you say moved out, that meant isolated?
Correct.
Yes.
Okay.
Yes.
I'm going to be very clear with that. That's not like just a transfer. It's I'm going to move you off to a dark corner in the office and you're not going to talk to anybody anymore.
Yes, Chairman.
Okay.
I'm sorry, Donna, please go ahead.
Yeah. The next one would be violation of the whistleblower statute, party to simulating legal process. And I would describe this as recklessly causing a document to simulate a summon or another court process, and this relates to Kamek. Party to impersonating a public servant, again, this relates to Brandon Kamek, identifying himself as a special prosecutor. We talked about the appearance of bribery, like a quid pro quo, that if, you get money, you get benefits, then you'll use your discretion for my benefit. Another was dereliction of duty. To be negligent is one thing, but malfeasance, when you are actively and intentionally doing things to the detriment of the office and to your oath and to the responsibility that you have to the state of Texas and the public.
And that would include failure to look out for the best interests of a charitable organization?
Most definitely.
Okay.
And then, loss of trust. I know you talk about breach of trust. And I think almost universally, when we were talking to the whistleblowers, it was like I, needed to leave if I resigned. And it was a total loss of trust. And these were people who had known him for a while, but after all they went through and observed, they said, the trust is gone. And then the false statements, false statements put out in a derogatory manner about the whistleblowers, making a statement, a public statement saying that Travis County had given him this complaint. It's like it originated from them as opposed to it originated from him, because he hand carried Nate Paul over to the Travis County DA's office. So, I could go on and on, but
I would add one thing, Chairman Murr. I think in relation to many of these crimes, there's, of course, the aiding and abetting portion of it. He's acting with other individuals, and conspiracy to commit crimes and that violate both the state of Texas laws and federal laws.
That is a pretty comprehensive list of concerns that's alarming to hear. It curls my mustache. Mr. Spiller has questions.
Yeah, briefly, thank you, Mr. Chairman. And I know some of these may be criminal offenses that are alleged that General Paxton may have violated. Some of them may be just related to the breach of his duty and oath
Yes.
in and to the office. You mentioned the classification, and I'm familiar with the punishment on abuse of official capacity, the securities fraud, the retaliation or official oppression. What about on misuse of official information? Do you know what the classification of that would be? If
misuse of official information is a third-degree felony.
All right, 2 to 10.
I'm sorry?
The range of punishment is 2 to 10 years, I believe.
Yes.
Yes.
And then what about and it may be related to the dollar amount, at least as to the $25,000 that we don't know whether was expended or not, but was the misapplication of fiduciary?
The misapplication is the state jail felony.
Okay. Thank you.
Thank you.
Can I clarify, just to further up on your question, the punishment range for a state jail felony would be 6 months at a minimum and 2 years in a state jail facility.
Early on, you mentioned something about a $100,000 donation from somebody. Whatever happened with that allegation?
My understanding is that it was investigated, substantiated, believed to be actionable. I'm going to dance a little because I don't want to make implications about someone I've not met and don't understand. When it arrived in the actual jurisdiction's concerns as to whether or not those allegations should proceed, and at the conclusion, presentation was made that it wasn't valid, and law enforcement's impression was the statute of limitations had run, so it wasn't actionable anyway. It was not an absence of facts or evidence sufficient to support the elements underlying an improper gift to a public official.
Thank you.
Speaker Guerin,
Can we stay on that $100,000 for just a minute?
your button didn't click.
The $100,000 was not reported as a campaign contribution, but was described as a gift. Is that correct?
That's correct. As a campaign contribution, there would have needed to be a notice or a disclosure to the Texas Ethics Commission as a donation. That does not occur.
All right. Was it disclosed to the Ethics Commission as a gift?
Thank you. No, sir, it was not. Not until it was caught, or until the question was asked.
So it was, I'm assuming then, the general made a corrected return to report the $100,000 as a gift.
I frankly, at the point in which there was illumination and a correction, I did not look for substantiation in regards to cleaning up the mess that had already been aired. So I don't know.
So basically, they just said it was a gift and wait, I mean, who told you it was a gift?
Let me clarify.
Okay.
And I'd rather get to my notes to make sure that I don't get over my skis. Okay.
And was this $100,000 for his legal defense fund or?
That's what I was trying to distinguish. If we're talking about the $100,000 in regards to Servergy, the answer is different than if we're talking about the $100,000 for the defense fund. The answer to both, upon a lack of disclosure, is, oh, it was a gift.
Okay.
But the explanations as to how that happened are different.
All right. Thank you, ma'am.
Yes.
Did that clear up your questions? Were you asking about the securities issues, or are you asking about I guess, contributions in order for him to pay for his legal defense.
I guess where I'm trying to come from is, not many people walk up to me and give me $100,000. It doesn't happen very often. In fact, I don't believe it's ever happened. And we as electeds have to report gifts. We have to report campaign contributions. And I'm trying to get it straight in my mind where this $100,000, where both the $100,000, where they actually fit. We just filed personal financial statements, which, for the last year. I'm just trying to figure out where the $100,000, the two $100,000, where they showed up and where they should have showed up. And now I'm still confused.
I understand.
I would love to illuminate that for you, but there is an absence of information specific to that available to this inquiry.
That's why I'm going to stay confused.
Yes.
Thank you.
Other questions right now? And I know we haven't finally wound up, but is there any other areas of your investigation that you would like to share, or any other observations or conclusions?
I would like to add that it has been an honor to work for and with these people, but also to emphasize that as we have gone through, when there are questions or concerns and decisions to be made, to the extent that anything is wrong, it is my responsibility. To the extent that it was well done, it is the team that was incredible.
Can I make a comment? You were assembled here because of the what we've now referred to as the whistleblower litigation, and the fact that those parties arrived at a mediated settlement agreement that totaled $3.3 million. And Speaker Garrett, I've never seen $3.3 million. It sounds like a lot of money, and it is. Part of that.
The 100,000 was a lot of.
Yes, right. Part of that, however, the request was made that the legislature fund that amount. So I have a couple of questions. One, in the course of that litigation, to the best of our knowledge, Mr. Paxton has never been deposed or appeared in court and offered sworn testimony in any way. Does that sound accurate?
That is consistent among any lawsuit in regards.
Consistent with.
Paxton, as I understand it. But yes, in regards to the lawsuit, no discovery and no depositions.
Let me just clarify.
Well.
That is consistent with every lawsuit that you're familiar with that Mr. Paxton's been involved in. He has not provided sworn testimony in some way.
That is correct.
Okay.
I would like to clarify my statement a moment ago. When I said there had been no depositions, there were depositions on preliminary matters, but not the facts of the case.
Gotcha. The second part is trying to get to the basis of the claims of the whistleblowers involved in that. Hearing all this information and hearing good people who've provided years of public service, and you all sit here having done that both at the federal and the state level, can empathize and sympathize with someone who is trying to do their job, trying to do it the right way, and then found themselves to be on the outs for doing the right thing. And it seems that's very clear. It is alarming, I said earlier, and very serious as to having this discussion and why millions of dollars have been asked in taxpayer dollars to remedy what has alleged to be some wrongs by various people. So that's something that we have to grapple with as challenging. I'm still soaking in many of the facts that you have provided us with your level of detail and the many hours that you have spent visiting with folks, visiting with these whistleblowers, visiting with witnesses, and reviewing hundreds of documents. Do y'all have anything else that y'all would like to add or ask questions of?
I would just like to thank this panel, this group of people, for the excellent job that they've done and the hours and very detailed information they provided us. Thank you.
Thank you, sir.
On behalf of the entire committee, we appreciate each and every one of you and the efforts that you have put forward to bring us information. And as you stated at the beginning, Ms. Epley, so eloquently, that your task was not to pass judgment. Your task was to figure out what the facts were and where they led you. And behind you, you have qualified investigators that helped you do that as well. And for all of that, you should be commended. You have a lot of work that you put together today. Seated to my right and your left is a court reporter who has taken down each and every word that has been provided. It is the intent that that will be transcribed. Members, do you have any other questions for our invited witnesses here today? And we appreciate that. And for that purpose, we excuse you.
Thank you.
Thank you. It's been a pleasure.
Without objection, the committee will now enter into an executive session under Subchapter B, Chapter 301 of the Government Code, the House Rules of Procedure, the Housekeeping Resolution, and the committee's rules. The time is 11:08 a.m. It is the intent of the committee to allow the public to remain in this room while the committee retires in executive session to an empty room behind the committee.